And welcome back once again to the National Lawyer Show. With me today is well-known personal injury attorney Michael Freedman. Michael, let's talk about the final process of going to court. You've already received what you think is the final offer from the attorney. How do you evaluate whether or not you're willing to go to jury on it?
Well, 3 C's that we look at. Number 1 is the case. Is it a case that we can win for sure? Are there any little factors that I know about that scare me that's possible that we could lose the case? For example, if we're in a contributory negligence state, is there something that the defense counsel can pounce on so that a jury might find my client negligent to some degree and I'm out of the ballgame? So the way the case is laid out, the way the accident happened, do I have a strong case? That's number 1. Number 2, we look at the actual costs involved in taking this case to trial. The more serious the injury, the more expertise the doctors have, the more expensive they are. And it is not unusual for a personal injury case to cost maybe $10,000, $15,000 that oftentimes either the client or somebody else has to put up to take the case to trial. So that's a major factor. Are you going to get that money back? Are you certain you're going to get that money back? And the 3rd C, which is really important, is the credibility of your client. So many of our cases comes down to, is my client believable? Is a jury going to believe the way the accident happened? Is the jury going to believe that that soft tissue injury that causes my client to not be able to sleep at night, are they going to believe the client? Are they going to believe that he's able to work but still have this pain? Are they going to believe that he's able to work out in a gym but still have this permanent disability? Credibility is tremendously important. And what makes it really interesting, Gary, is that I know from sitting with the client, from seeing the client go through depositions, I kind of know how the jury is going to perceive my client. And sometimes it gets very difficult when I'm not crazy about what that perception is going to be, and I've got to very delicately explain to my client that from a credibility standpoint, they might not be the most credible, very difficult to do that. And yet I know that I have to do that. For example, if the client has had some major problems, and maybe he's had 4 or 5 claims that he's brought up in the past, that's going to be a problem. The jury's going to look at that and think that possibly my client just likes to bring claims. So all of these things fall under the credibility. And those really are the 3 things that we look at. We sit down, we spell them out, and a lot of times I let the client come to the conclusion that I hope the client comes to.
If I could ask you about a 4th C maybe, and that's personal comfortability. Let's say I'm not comfortable going to trial. I think that I may be tripped up upon cross-examination or something like that. How does that affect it?
You know, it's a great question, Gary. I have clients who say to me, we're going to trial. I'm going to trial. And then when push comes to shove, they're scared to go to trial. People don't like to go to trial. People don't like to be on the witness stand. It is not comfortable. It just is not comfortable. And some clients will tell me, look, I'm going to be very clear with you, I'm not going to trial. And if I know that up front, then I can deal with that. If we're going to go to trial, we will sit down with the client and we will make sure that the client is comfortable. We'll go through the entire cross-examination process. I will be tougher on the client than defense counsel will be. I've had my own clients cry leaving my office because of my cross-examination. Maybe trial isn't the most, isn't the best way to go. It's a very good question, and it's something that we deal with all the time.
Michael Freedman, thank you so much for joining us on the National Lawyer Show.
My pleasure.